Hello guys and welcome back to another video in this series of legal maxims. In today's video we are going to look into another maxim called as voluntary non-fit injuria. Now in the everyday world, compensation, damages or even punishment is given to a person who is injured. But what happens in a case when an injured person himself was responsible for the damages he has suffered? So in such a case, that person will not be given any damages. That's when this legal maxim of voluntary non-fit injuria will come into picture. Now what does this voluntary non-fit injuria means? It means nothing else but a person who consents suffers no harm, or a person who voluntarily consents an act suffers no harm. This maxim belongs to the branch of torts. As you all will study, when a harm is caused voluntarily, it becomes a defense under tort. Now if you exactly translate this voluntary non-fit injuria into simple terms, it means that to a willing person no harm is done. Now this maxim is a common law doctrine, which means that if a person is willingly places himself in such a situation wherein the harm might be the result, knowing that to some degree the harm might be the result, then in such a case no defense will be given to him under the law of torts. If a boxer consents to being hit and to the injury that might be expected from such a boxing match, then in such a case no compensation will be given to him since he has agreed to such a match. Voluntary non-fit injuria is also known as voluntary assumption of risk. Which means that sometimes a person should voluntarily assume such certain risks. In such a case we can take another example, that is when a person jumps from a cliff, it's quite obvious that harm or even death might be caused to such a person. So certain assumptions from a prudent sense should be made. Voluntary non-fit injuria sometimes is also described as the plaintiff consenting to a risk. In this context, voluntary non-fit injuria can be distinguished from a legal consent, in that the latter can prevent some torts arising from the first. For example, a consent to a medical procedure prevents the procedure from being a trespass to a person. If you invite a person to your house, then in such a case such a person will not be considered to be as a trespasser. Furthermore, if we look more into the torts related aspect with regards to this maxim, we see that the defendant had not forced the plaintiff to face the liability, but the plaintiff himself faced the act. So therefore, once the court applies the maxim, defendant is discharged from any such liability. Now for this maxim to be applicable, there are two main criteria. Firstly being the consent, and secondly being the knowledge of the risk. Now if you look into the consent, such a consent must be free. Such a person should not be forced into doing such an act, or coerced into doing such an act. So in such a case the consent will be free. Furthermore, if we look into the knowledge of the risk, the person has to have the knowledge as to how much risk, that is, person should calculate how much the risk may be done. So he should have the knowledge of the risk to even go forward with it. Now next, let's look into few cases supporting this maxim. Let's first look into the case of Brookland Auto Racing Club versus Hall. Now Brookland Auto Racing Club organized a motor race rally. Hall booked a ticket and went for the racing competition. He entered and was watching the race when one of the cars collided with another and he suffered an injury. Later, Mr. Hall went to the court asking for compensation. The court said that voluntary non-fit injuria, which means that when Hall himself voluntarily went to witness a rally, the danger being inherent is the sport, which any spectator could have foreseen. Hence, the defendant was not held liable. Let's look into few exceptions in this maxim. The first exception to this maxim is negligence. Now, negligence is an unlawful act. When an unlawful act is done, voluntary non-fit injuria cannot be applied. Another exception to this maxim can be a breach of statutory duty. The moment when a defendant breaches statutory duty, you cannot claim compensation and also cannot take the defense of voluntary non-fit injuria. The examples for this can be player injured while playing cricket, or even when a doctor is operating a patient. In such a case, voluntary non-fit injuria cannot be applied, as it's very important that knowing the risk fully before participating in such a risky event. Next, let's look into the case of Highness versus Hardwood. In this case, the defendant left the horse chariot unattended. A small boy standing nearby hits the stone to the horse and the horse gets startled. A constable witnesses the incident, realizing that this will cause a great nuisance and injury to the general public. So he makes an attempt to stop the chariot and he succeeds, but he instead suffers injury by himself. He filed a suit against the defendant to pay him compensation, and thus the matter came before the court. The court said that defendant in such a case was negligent. Negligence is exception to voluntary non-fit injuria. Now that's all for today's video, guys. I'll see you around in the next video. Take care. Bye.